Today we'll discuss if the state of Texas still has to prove a drug crime occurred if the defendant confessed. Every person charged with a crime in Texas has the right to demand a jury trial. At such a trial, the state must prove the defendant's guilt beyond a reasonable doubt. But what happens if the defendant pleads guilty and signs a confession? Does the prosecution still need to put on a case? A recent decision from the Texas 7th District Court of Appeals illustrates what happens in these situations. In this case, Ludall v. State, police conducted a traffic stop of the defendant. During the stop, officers searched the defendant's vehicle as well as her purse. Inside the purse, the officers found several baggies containing a substance later determined to be methamphetamine. Altogether, the state determined there was about 25.6 grams of methamphetamine in the baggies. A jury subsequently indicted the defendant for allegedly violating Section 481.112 of the Texas Health and Safety Code. This section defines the offense of possession of a controlled substance with intent to deliver, when the amount involved is more than 4, but less than 200 grams. This offense is a first-degree felony, punishable by between 5 and 99 years in prison and / a $10,000 fine. Before the trial court, the defendant pleaded guilty and signed a waiver of her constitutional rights, which included a confession to the underlying charges. The trial court found the defendant guilty and sentenced her to 10 years in prison. The defendant then appealed, arguing there was insufficient evidence to support the conviction. Specifically, she argued the evidence only established possession of methamphetamine, but nothing more. The Court of Appeals rejected that argument and upheld the conviction. It explained that in cases like this, where a defendant voluntarily pleads guilty, the prosecution was still required to introduce evidence demonstrating the defendant's guilt, but they did not have to prove that guilt beyond a reasonable doubt. Instead, the evidence must simply embrace each essential element of the offense charged. Here, the defendant's signed confession was sufficient evidence to establish each essential element of the offense of possession with intent to deliver. Indeed, the Court of Appeals noted the trial court approved and referred to this confession in its own judgment. As such, there was sufficient proof to support the defendant's conviction and 10-year prison sentence. While there are circumstances where you might decide it is better to plead guilty to a drug charge, you need to carefully consider the consequences beforehand, especially if you are facing a felony punishable by a decade or more in state prison. And you should never make such a momentous decision without first consulting a qualified San Marcos drug crime lawyer. The law offices of David C. Hardaway can review your arrest, advise you of your rights, and provide you with a zealous defense against such allegations. Contact us today at 512-805-66132 to schedule a consultation.